Good morning, everyone. Welcome to NOVA 401k Associates webinar on a 2021 update, Secure Act guidance, and retirement provisions in the 2020 stimulus bill. Today's webinar is eligible for CFP, ASPA, and IRPA CE credit. Right after the webinar ends, you will see the survey pop up if you are needing one of these credits. We have also added the slides as a handout. Just click the handout drop-down on your GoToWebinar panel, and you can download and save the file to your local folder. Today's presentation will be presented by Craig Hoffman. Craig is an attorney and senior consultant at NOVA. He has over 35 years of experience focusing exclusively on federal tax and ERISA matters relating to the design, implementation, and operation of tax-qualified retirement plans. If you have any questions, please type them in the questions box and we will answer them throughout and at the end of the presentation. Craig, we're ready when you are.
Thank you very much. Hello, everybody. Yes, the disclaimer, we got to have the legal language there. If you need CPA credit, that's our provider number. Again, these slides are included in the handout. If you need to download them, please feel free to do so. Today's webinar is going to be a bit of a grab bag of some current guidance that has come out, and as well as the recently enacted stimulus legislation signed December 27th, had some provisions dealing with retirement plans, so we'll start with that. Then we'll segue into the IRS guidance we've gotten under the Secure Act, namely Notice 2020-68, which is a grab bag of guidance on a number of different sections in Secure, as well as Notice 2020-86, which focuses on the Safe Harbor Plan changes under Secure and provides some initial guidance. Both of those notices are intended to be just that, initial guidance. We will ultimately get regulations on this, but obviously, or maybe not so obviously, the Secure Act was passed at the end in December of 2019 with provisions which became effective 2020. And so there is a need to get at least some questions answered, and the IRS has done so. Sandwiched between those two Secure Act topics is another Secure Act topic. We haven't gotten any guidance on it recently, but it is a provision under Secure that is ripe for being used right now. It's the change in the deadline to adopt a new plan in order to generate a deduction for a tax year. We'll go through those provisions as well, and hopefully you'll have an opportunity maybe to put that into practice in the weeks and months ahead. So let's go to the Consolidated Appropriations Act of 2021. Even though it was signed in 2020, it covers its main purpose. If you might recall, the government almost shut down in December. So what this bill did was extend the funding of the federal government through the end of the current fiscal year, ending 9/30/2021. But as is often the case with a must-pass bill, other things were added to it. A number of the things added dealt with more relief for the pandemic, and several of the provisions impact qualified retirement plans. That's what I'm going to focus on. One of the issues that has come up in the context of the pandemic are the application of the partial termination rules under the Internal Revenue Code. Code Section 411D3 requires a plan to fully vest affected participants upon the termination or partial termination of a plan. Now, whether a partial termination has taken place, if you look in the regs, it says it's based on all the relevant facts and circumstances, but I think as a practical matter, what this has developed into, the one factor the reg list has become the most predominant factor, and that is the number of participating employees who are excluded from further plan participation by an employer-initiated severance from employment. So there's a whole lot there. So if you have been let go by your employer, then that is an employer-initiated severance. And generally speaking, the courts and the IRS have adopted a presumption, if you will, that if at least 20%, if there's at least a 20% turnover rate, that during the applicable period, which is typically the plan year, if it's at least 20% or higher, it's a rebuttable presumption that a partial termination has taken place. If it's less than 20%, it's conceivable the IRS could challenge, but court cases have suggested that between 10 and 20%, it's a rebuttable presumption that no partial termination has taken place, and that over 40%, it's an irrebuttable presumption. So bottom line, where we play around at the margins is at 20%, and maybe based on some very particular facts and circumstances, you might go up or down by 1% or 2%, but that's what we generally are looking at. And for that turnover rate, we look at the number of active participants at the end of the year and divide it by the number of participants at the beginning of the year and the active participants added during the year, and you get your number. And if that turnover rate's 20%, the IRS is likely to suggest or take the position on audit that a partial termination has taken place. Now, the pandemic has come upon us, and needless to say, many employers have had to lay off their workforce due to the economic conditions in the country. Now, a couple of points to be made there. The IRS indicated that if the employees who were laid off were rehired before the end of the year, the applicable period, at least for calendar year plans, they would not be treated as having had an employer-initiated severance from employment. And there was hope many of these employees could be rehired. The IRS put that on their website in the summer, I believe, of last year, and there was hope many people would be rehired by the end of the year. Now, a question often comes up in this discussion, well, you know, the employer didn't want to fire these people. They had no choice. The country shut down. And you know, there is no specific ruling on the pandemic from the IRS, but there is a ruling or a position they've espoused very clearly that to the extent economic conditions have caused a layoff, nevertheless, that is still considered to be an employer-initiated severance from employment. And I'm not aware of any intention of them changing that position because of the pandemic. I might add as well, I mean, obviously the pandemic has shined a light on this particular issue. The IRS puts out their enforcement efforts, their plan for the coming year. And listed in their compliance check department, not actual an audit program, but where they send out letters to employers saying, we see something that doesn't look quite right. Can you explain this to us? Well, one of the letters they at least have indicated on their website, an area they're going to probe is whether a partial termination has taken place. And they're going to look for candidates to receive that letter based on the active participant counts on the 5,500. So it's going to be important to keep an eye on this right now because it is certainly possible clients may be hearing from the IRS as a result of layoffs that occurred during 2020. Now, the original CARES Act did not address partial terminations, did not provide any relief. And so prior to the stimulus bill, the normal rules would have been applicable, and therefore it's likely many plans would have had a partial termination in 2020. Therefore, they would need to fully vest all their participants. Now, CAA, the stimulus bill, there was some efforts to get relief, and they succeeded. How useful they will be remain to be seen, but they certainly need to be applied to your plans to have the opportunity to potentially take advantage of it. What the new law essentially does is extend the period for measuring whether you rehired people by 3 months for calendar year plans, at least. It's kind of convoluted, the effective period it applies to. I'll come back to that in a second. But so normally, for 2020 calendar year plans, you'd look at who you rehired by December 31. As of with CAA, it extends the period for making that determination until March 31, 2021, the end of next month. Now, obviously, this is only going to be helpful to businesses that were able to recover by March 31, 2021. But it also, to be candid, may be helpful to businesses that might have a partial termination under the normal rules, even though they had started operations by December of last year. I'll come back to why that might be the case. The wording in the law itself is odd, as I mentioned. It says a plan should not be treated as having a partial termination during any plan year, which includes the period beginning March 13, 2020 to March 31, 2021. Now, the folks I've spoken to are interpreting that to mean that you don't have to include the entire period since it's longer than 12 months, and the intention is if you've got at least one day in that period that's in a plan year, you can get protection for that plan year. And I'll come back to the rest of the test in just a second, but focusing on, well, let's go back to this too. So what we're looking at is whether the number of active participants covered by the plan on March 31, 2021 is at least 80% of the number of active participants covered by the plan on March 13th, 2020. So it's a very rote objective test, and it's basically pegging March 13th as, the day it all began before the layoffs really started. So we go back to see how many active participants were in the plan on that date and compare it to March 31. And so for a calendar year plan, it essentially gives you an extra 3 months. The starting date is March 13th, but I don't think there's any reason to believe there'd be much difference between your active participant count on January 1, 2020 and March 13th, 2020. So for calendar year plans, the test simply compares those two active participant counts. Now, for a calendar year plan, gives you 3 months. For a non-calendar year plan, these rules do apply, but it doesn't seem to meld as well. If you've got a February 1 plan year beginning date, then you basically are getting an extra 2 months. If you have a March 1 beginning date, you get an extra month. If you're a one of a plan year beginning other than those 3 months, it appears this would still apply, but you're making the determination based on these two rote dates, March 13, 2020 and March 31, 2021. It is what it is. So if there's an opportunity to apply it, you should, and it could even have application to the 2021 calendar year plans, because calendar year 2021 plan year includes part of the period that includes, from January 1, 2021 to March 31. So it could have broader application, and it is something that will need to be considered. Now, the second significant change made by this relief relates to who needs to be rehired by March 31. Normally, for purposes of determining whether you've had a partial termination, you look the employees who were severed must be the employees who are rehired in order for that severance not to be treated as an employer-initiated severance from employment. Now, the stimulus bill recognizes in the economy, the pandemic that we've been dealing with, things have been upended. We've been closed a lot longer than we thought. Employees have moved on. They may have found other jobs. They may have moved to other parts of the country. And businesses that are reopening may not have the luxury of being able to rehire the same people. And so what this relief does is throw that by the wayside. It is a rote determination of the number of active participants on March 31 of 2021 and compare it back to the March 13th count of active participants. So this overrides the normal rules, and all you need to do is look at active participant status. Now, that can be a little tricky. Think of Tom's Restaurant, sponsors a calendar year K plan. Everybody's eligible as soon as they're hired. Things were good on March 13th, 2020. Tom had 50 employees. All were in the plan because they had fulfilled eligibility. Unfortunately, May 1st, Tom had to shut the restaurant down and let everybody go except himself. But good things happened in February of this year. He had a grand opening a few weeks ago. I was invited. No, I'm just kidding. But in any case, he reopens February 2021, and let's assume by March 31 of this year, he's back up to 45 employees, including himself. So the question posed, did Tom have a partial termination under the normal rules? I think the answer is yes. Certainly the IRS would say that. There is potentially an argument on the facts and circumstances that the applicable period could be extended beyond 12 months because of the pandemic. To be candid, I haven't really looked that deep into it. Maybe you can make that argument, so you're still looking on whether you've rehired those same people. And maybe you can make an argument in the pandemic, you don't have to rehire the very same people. But apart from kind of grasping at those extra straws, the IRS would say, you've had a partial termination, Tom. You had 98% turnover rate as of the end of the calendar year, plan year applicable period. Well, now we take a look at the relief. If we apply the relief to Tom's plan, did he have a partial termination? And the answer is no. Because on March 31, he's got 45 employees, all are active participants. And on March 13th last year, he had 50. 45 divided by 50 is 90%. He's only had a 10% turnover rate, and it worked swimmingly. But keep in mind, Tom's plan had immediate eligibility. So all these new hires immediately came into the plan as active participants. What if instead Tom's plan required 3 months of service to be eligible to make elective deferrals, and only 10 of the rehired employees who were rehired in February, or only 10 of the rehired employees were former employees and therefore immediate entrance into the plan. In that case, the turnover rate goes up to 80%. The turnover rate is 80%, and therefore the relief doesn't apply. Even though he's resumed operations and has rehired employees, the standard is based on the number of active participants. Could Congress have written that law differently? Sure. But it is what it is. And so what if Tom's plan allowed for a profit-sharing contribution or matching contributions, and you had to have a year of service for that, but you were immediately eligible for elective deferral? So those 35 new hires were immediately eligible to make elective deferrals. The question begs, does that make them active participants? And I think the answer is yes. For purposes of the 5500, for purposes of coverage testing, the IRS and DOL view eligibility to make elective deferrals as conferring active participant status. So I feel pretty comfortable with that. The point I'm leading to, however, it's now February 18th, I believe, and March 31 is 6 weeks away, 5 weeks away, somewhere in there. In any case, the point being is, by the time people think about taking action to perhaps amend the plan's eligibility to let people in, it may be too late. So it is what it is. The relief may or may not be all that helpful. Obviously, if you resumed operations in 2020, you should take a look at it. But again, if you resumed operations in 2020 and didn't rehire the same people, you may still need to avail yourself of this relief. So is it going to solve everybody's problem? No. But it's, as my father used to say to me, Craig, it's better than a stick in the eye. And I was always perplexed because I couldn't think of anything that wasn't better than a stick in the eye, but I found myself saying that to my own daughter as well. Bad habits come down through generations. All right, moving on. Also in CAA was a disaster relief. This is what Congress has passed periodically. I'm going to go through it quickly. We've had this before for prior disasters, hurricanes, and the like. This is for the period that began January 1st of last year and ends in a week, February 25th. It applies to disasters who have an incident period within that time frame. You can go on the FEMA website, and I gave you the link there, and you can see what may fall within these disasters. And there are things like the hurricanes we had through the Gulf. I know obviously the Texas and Louisiana Gulf Coast was hit pretty hard, and so there may be some application availability. This is optional. You do not have to add qualified disaster distributions to your plan. And it's kind of got the designation has. Oh, let me back up too. I should have also pointed out that this does not apply to areas specifically declared a disaster as a result of COVID. So it's only applying for disaster areas other than COVID, but there are a number of places that had, the wildfires that are designated as disasters for both purposes. So what is a disaster distribution? One made on or after the incident period, which is on the FEMA website, and before June 26th of this year. I think it was 180 days after the date of enactment. To an individual who suffered an economic loss as a result of the disaster, whose principal residence was located in that qualified disaster zone during the period of the disaster. So what does that do for you? Up to $100,000 is exempt from the premature distribution tax under 72T, that 10% tax that applies generally if you're not at least 59.5. The disaster distribution can be rolled back into a plan or IRA for up to 3 years after the date of distribution, and the recipient can report it as income ratably over 3 tax years. Excuse me. The disaster relief also allows you to increase the participant loan limit to $100,000 for loans made beginning December 27th, 2020 through June 25th. It allows for a suspension of loan repayments. This is patterned. The COVID relief was patterned on the same path federal disaster relief. So if you're familiar with that, it's the same song we're playing, just with a slightly different chorus, I guess. If you got a hardship distribution to buy a house and then you couldn't close, it was in a disaster area, you can repay the distribution. I'm not sure there's a lot of that. What it does do is allow 401k, 403b, and governmental 457 plans to allow restricted amounts, elective deferrals, QNEX, QMAX, to be distributed in service before age 59 and a half, if it is a qualified, whoops, I went too far. If it was a qualified distribution. So the law doesn't mandate that you add this. Actually, goes both ways. The law doesn't mandate that you add it, but the participant is eligible to claim that treatment irrespective of whether the plan allowed for the in-service distribution before age 59 and a half. So that's really the point I wanted to make there. Moving on to COVID distributions. This is, I jumped ahead, but it's similar topic, so that's why I jumped ahead unintentionally. In any case, we had the COVID distributions for qualified individuals. Again, pattern very much on that disaster relief. It allowed in-service distributions from K, 403B, and 457 without violating the in-service distribution rules. It did not allow money purchase plans to do it. The stimulus bill allows money purchase plans to make COVID-19 distributions without violating the in-service distribution rules. And I bring this up because this is perhaps the silliest provision in the whole bill. As I said, the law was signed December 27th. The last day to make a COVID distribution was December 30th. So maybe it had application to folks who made illegal distributions hoping this would come through. I don't know. But in any case, this does not affect a qualifying individual who got a distribution from a money purchase plan to claim it as a COVID distribution. All right, we need to pick up the pace here. Notice 2020-68. Long-term part-time employees. We are actually going to do a webinar in April exclusively devoted to the long-term part-time employee issue. Obviously, we are focusing here in the grab bag guidance on what we learned from Notice 2068. And what we learned is that, generally speaking, you're a long-term part-time employee if you complete at least 3 consecutive 12-month computation periods with at least 500 hours. This is effective for plan years beginning after December 31, 2020. However, under Secure, you are able to ignore credit for eligibility purposes served before January 1st, 2021. I'm going to skip ahead. We're going to come back to this later, or in April. I want to save time to get it more clearly. What the 2068 does is make it clear to us that the vesting rules run differently than the eligibility rules. Now, an employer is not required to make any contributions on behalf of long-term part-time employees. All that's necessary is you allow that person to be eligible to make elective deferrals. But if an employer makes a contribution for a long-term part-time employee, then the vesting rules are applied by crediting a year of vesting credit for any year in which the employee had at least 500 hours of service. And these special vesting rules only apply to employees who are eligible to participate solely by reason of being a long-term part-time employee. But unlike many of the other provisions for LTPTs, if a long-time part-time employee eventually completes 1,000 hours, the special 500-hour vesting rule continues to apply. So this is going to be a bugaboo. What Notice 2020-68 tells us is that although it is permissible to exclude service prior to January 1 of this year for eligibility, it is not It is not permissible to exclude service prior to this year for vesting. And if you read the Secure Act, I think it does in fact say that. Now, in Notice 2020-68, the IRS acknowledged that this is going to cause administrative burdens. And they actually requested comments on how those burdens may be reduced, because in my mind, I don't think Congress really considered the administrative hassle this is going to cause, trying to look back in time for part-time employees to figure out how many years of vesting credit to get them. NOVA, we wrote a comment letter to the IRS on the notice, and we suggested that there should at least be a fresh start date, and we recommended 1/1/2016. It remains to be seen how this is going to play out, but again, I think there's more. We are planning to do a webinar, I believe, April 6th, exclusively devoted to long-term part-time employee issues. So although it seems like it's still a couple of years off, I mean, we need to be dealing with it right now. What else is in 2020-68? The Iaca Tax Credit. This is a tax credit for small employers, i.e. one who in the preceding year had no more than 100 employees who were compensated at least $5,000 or more. So if you're a small employer and you add an Iaca, an automatic enrollment, to your plan, you get a $500 tax credit for the first, second, and third year of adding that automatic enrollment, and that began for 2020. That's great. What the Iaca guidance clarified is that an employer joining a MEP, since the auto enrollment credit only applies for the first 3 years the plan has automatic enrollment, the question arose, well, I'm joining a MEP, and for me, my company, we are adding auto enrollment for the first time as we join this MEP. Do we get the credit? Even though auto enrollment's been a part of this MEP and other employers, perhaps for years, and the answer in 2020-68 is yes, you get the credit. What they didn't answer in 2020-68 is what about the small employer startup credit? When a small employer starts a new plan by joining a MEP. My reading, and I think others' reading of Secure would lead me to believe no, that if that MEP has been in existence for 3 years, because the small employer startup credit is for the first, second, and third year of the plan's life, and if the MEP's been out there for over 3 years, you've already blown through that first 3 years. Now, whether the IRS will reach that conclusion or not, our comment letter on Notice 2068 suggested that they should clarify the same approach for the Iaca credit applies to joining MEPs. They haven't called us up to say we'll get right on that, so we'll see. And I should add the Secure 2.0 next round of retirement reform has a provision that clarifies if IRS doesn't do it, Congress will fix it in essentially a technical correction to make it clear it will apply when a small employer starts a new plan by joining a MEP. Qualified birth adoption distributions. This was part of Secure. It was added at the behest of Kevin Brady, the ranking member of the House Ways and Means Committee. Basically, any distribution made during the 1 year period beginning on the date on which you either have a child born or legally adopt a child, you are entitled to take a distribution of up to $5,000 that's exempt from the 10% early distribution tax. Whoopee. Oh, well, maybe because I'm beyond the age of having children. But in any case, I need some grandchildren, actually, was what I am working on, but my daughter has told me to chill. In any case, I digress once again. The point I want to make about this is this is another one of those provisions where it would not violate the in-service distribution rule. So if plans want to add a QBAD type distribution, they can do so an employee can get the money early. I don't think plans are going to be running to do that. But like disaster distributions, if a person gets a distribution for that is he or she is otherwise qualified for at a time within 1 year of having a kid, they can qualify for this QBAD treatment, which on top of being accepted from the 72T tax can be repaid to the plan if the individual is still eligible, and that's kind of how the wording reads. And it appears that you will not need to, if you can make the QBAD, you don't have to take it back. But it also appears you can pay back the QBAD distribution anytime. There literally is no limit, no 3-year period or anything else. We'll see. We'll need guidance. The one thing that bothers me, that concerns me, and we commented on this as well, is the 2068 says the plan administrator must treat that QBAD as a distribution ineligible for rollover, which means you don't have to go through the 402F notice. You don't have to provide for direct rollovers. It's subject to the voluntary withholding rules, for which you do need to give a notice, and there are higher penalties under secure if you don't. My problem with that is you, as the plan administrator, may not have any idea whether the distribution you're making is a QBAD distribution, at least in the hands of the participant. You know, you've got Johnny who terminated employment last year, and after he was gone, had a child, and now gets his termination distribution within 1 year of the birth of this child. That's a QBAD. And the plan administrator's got no way of knowing that. So I'm hoping the IRS, they have for other similar, for COVID distributions, they allowed the plan administrator to treat it either way if they didn't have the actual type of distribution authorized under the terms of the plan. So that's something we will need to look at. Boy, we're having fun, aren't we? Hip hip hooray. New deadlines for adopting a new plan. Let me wet my whistle, please. So in the past, I mean, I spent 24 years working for SunGuard. Before that, it was called Corbell, Broadway and Seymour in between. It's now FIS. I was in the world of documents, and in the early days, we worked Christmas Eve, we worked double time the week after Christmas and the week leading up to it. Why? Because we were printing out plan documents and mailing them to people so they could sign them before the last day of the year and get their deduction. And you know, that was troublesome, even more so because many small businesses particularly don't even know what how profitable they have been during the year until after the year is over. But the tax rule said you got to sign that plan and adopt it by the end of your tax year in order to generate a deductible contribution for that tax year. And so that all changed with the passage of the Secure Act late in 2019. The new law specifically allows an employer to adopt a new qualified plan after the close of the taxable year and still claim a deduction. The only requirement is that the plan must be adopted no later than the due date, including extensions, if they're specifically requested and received, until the due date of the tax return for the year. And so this new rule is effective for tax years that took effect after 2019. So we are now, for the first time, being able to use it for our calendar year taxpayers as they have closed their books and looking at where they stand from a profit margin for 2020. And although we were in a pandemic, let me tell you, there were some businesses that did very well during the pandemic. And so there are opportunities to shelter some of that income, even now, by adopting a qualified plan. Now, the due date for your tax return is going to depend on the type of organizations sponsoring the plan. C Corps have until April 15th for a calendar year plan with a 6-month extension. S Corps and partnerships have a 3/15 deadline, and their extension is till September 15th. Sole proprietors have April 15th and the October 15th deadline. These deadlines were played around with about 4 or 5 years ago with the intention that you'll note the pass-through type entities, partnerships and S corporations, they have a due date earlier than everybody else, so everybody else can get the information in order to report any income passed through to them by a partnership or an S corporation. So it's important to remember that you got to sign the plan, but you've also got to write the check and contribute to the plan again by the due date of the tax return. With that said, if you are on extension, there may be an earlier deadline to fund a defined benefit plan, making it a de facto earlier deadline. Under the funding rules of 430, the deadline generally is 8.5 months after the close of the plan year. So for calendar C corporation, the deadline is going to be September 15th, even though the extended deadline to file the tax return is a month later. And if you don't meet the funding deadline, then you can get hit with excise tax for the funding deficiency. So if you're, and it's also important to remember that people who want to put in a plan, don't wait until, if the DB plan, until September 14th or 13th. You know, it takes time to put in motion the wheels to get everything signed, sealed, and delivered, but clearly we have a lot easier row to hoe under Secure to shelter some of that income than we have ever before. It's important also to point out that the elected deferral contributions can only be made out of compensation that is paid after the cash or deferred arrangement is adopted. And since the cash or deferred arrangement isn't adopted until sometime in 2021, you can't, if you adopt it as part of this plan, you can't make that retroactive. You can add, adopt a 401k plan, generate a profit sharing contribution for 2020, and have the cash or deferred provisions be effective on a prospective basis. So let's just keep that in mind. What else? All right, we'll finish up here, sprinting for the finish line on the last bit of grab bag guidance from the IRS Notice 2020-86. And it hit several different aspects of safe harbor plans as changed by Secure. Off the top, the QACA maximum cap on how high you can auto escalate somebody has been 10%. Secure increased that to 15%. So under the new law, the initial period is the year you're hired, and the next year you're at 3%. The third year you go up to 4%, yada, yada, yada. Now you can go anywhere from 4 to 15. It's got to be at least 4. It could be higher. Now the highest limit is going to be 15%. I'm not sure anybody's rushing out to take advantage of that. What the notice indicates that if your document says you've got a 10% limit, it's written into the document, and that's what you want it to remain, you don't need to amend the plan for Secure. You don't need to do anything. If you have 10% hardwired into your plan and you'd like it to be higher, then you will need to amend your plan. but you will have until the deadline for Secure Act amendments, which is 2022, generally. 2024 for collectively bargained and governmental entities, I believe. The notice raises, what if your plan incorporates the maximum limit by reference to the Internal Revenue Code? I don't know that I've ever seen a plan that does that, but if you have one, then the IRS says by incorporating, it automatically goes up to 15%. If you want something less, you'll need to amend the plan. Again, you can affect that operationally and do that as part of the Secure Act amendment. More noteworthy in this notice was the guidance dealing with safe harbor notices, particularly with regard to plans that satisfy the safe harbor contribution requirements using a qualified non-elective type contribution. The Secure Act eliminated the notice requirement for plans meeting the ADP safe harbor using non-elective contributions. The thinking was that this, if your contributions don't depend on how much elective deferrals you are making, then you don't need this notice. But you still do need it if you're making QMAC contributions, and as we'll see, you may need it otherwise in matching contribution plans generally. Getting ahead of myself. The reason why this may have not as broad an application as we thought is because many safe harbor plans that use QNEX to satisfy the safe harbor contribution requirement have those QNEX do, in effect, double duty, where the same QNEC contribution gives you a free pass on your ADP test, but also gives you a free pass on your ACP test. And so the ACP test has some other parameters in terms of the matching contribution rate can't go higher as the deferral rate goes up. You can't have a higher rate of match for holidays versus non-holidays. Discretionary match has to be limited to 6%. But with that said, there are many plans that design their matching formulas to be within that ACP safe harbor and don't have to test the match or ADP because of the QNEC that went in. Under the Secure, however, the ACP test safe harbor still requires a notice. So if you are relying on a QNEC to also allow you to pass the ACP test, then you still need to give the safe harbor notice. And so, as a practical matter, the notice goes away only for plans that don't have matching contributions or actually test those matching contributions under the ACP test. And as I haven't seen a lot of plans that go that route. I will acknowledge many safe harbor plans are designed with QMAC, matching contributions, and this law change was never intended to apply to them. There is one little odd duck, and that is QMACs, or excuse me, QACAs. I'm going QACAs. The Qualified Automatic Contribution Arrangement, as it was drafted and added to the code later, does not have a notice requirement to get a pass on the ACP safe harbor. Why is it different than regular safe harbors? There's no logical reason for that. And as I've always said, the mistake you're making is trying to apply rational thought processes to why the law is what it is in this area. It was an oversight, is my best guess. I can't remember any discussion focused on that as QMAX came into the code. So what else? 2020-86 affirms that Iacas still need to give an annual notice to satisfy the Iaca requirements. It also highlights that even if you are a QNEC plan that doesn't need to give the notice, it's still the 401k regs require an employee to be provided with an effective opportunity to make or change a cash or deferred election at least once each year, also known as annually. And the notice reminds sponsors that whether you have that effective opportunity is based on all the facts and circumstances, including the adequacy of the notice of the availability of the cash or deferred election to make or change a cash or deferred election at least once each plan year. So they're just saying that you got to make sure people know they have that opportunity. So what else is addressed in this notice? Well, we've had the maybe not notice out there. The 401k regs say if during you start a plan year and you want to suspend contributions, you can terminate the plan, but if you don't want to terminate it and just suspend, then you must be either operating at an economic loss or you've got to give advance notice that maybe you may amend the plan to reduce or suspend contributions. And this maybe not notice provision came into the regs after the 2009 financial crisis, when it was hard sometimes to prove who was operating at an economic loss to suspend. And so this was welcome. I mean, it's hard not to be unhappy with it, but it does require giving out the maybe not notice. And Notice 2020-86 clarifies that if you still want this flexibility, even if you're a QNEC only plan, ADP tested, ADP safe harbor only, you still need to give the maybe not notice in order to have that flexibility. The guidance says you can give this as a standalone notice, but it still needs to otherwise satisfy the requirements for a safe harbor notice as far as timing, readability, things like that. And Notice 2020-86 came out, I think, in December. It may have been November, but it came out late in the year. And so the IRS gave everybody until January 31. If they missed that 30 days ahead of the 2021 plan year deadline, they gave them until January 30, 21 to get out their maybe not notice. Well, what about the maybe notices? Do we still need those? Well, that question arises because of a different provision in Secure where we can retroactively add a safe harbor arrangement to an existing tested 401k plan as late as even the last day of the following plan year. Prior to Secure, you had to have that safe harbor arrangement generally in place before the beginning of the year, with the one exception, the so-called maybe notice approach. And the maybe notice was around before the maybe not notice, but I digress again. The maybe notice basically says you give out a notice before the beginning of the year, part of your safe harbor notice, saying, maybe we will, maybe we won't. We'll let you know, and we will amend the plan before year end to do so. And then we have up to 30 days before the end of the plan year to give the supplemental notice to turn on the safe harbor provisions. And arguably, you can do this from year to year to year if you want. Now, since Secure allows us to retroactively amend the plan to add a safe harbor QNEC arrangement up to 12 months after the end of the plan year, it's a new rule. And the Secure Act provisions are more generous. You can amend the plan if you do it at least 30 days before, more than 30 days before the end of the plan year, and focus on that, more, not at least, more than 30 days. It's a 3% QNEC contribution. Anytime up to the end of the following plan year, it's a 4% contribution. No notice required, but ultimately it's disclosed through a summary of material modifications. Excuse me. So the notice clarified that you can use this provision to reverse an earlier decision to suspend or reduce safe harbor QNEX, but you can't use it to reinstate safe harbor match contribution. It also clarifies that the retroactive adoption rules do not change the deadlines for deductions or 415 annual additions crediting. So that assume an employer adopts a 4% QNEC November 1, and they make the contribution that same day. Well, the extended due date, assume it's a C Corp, was October 15th, 2021. They extended their tax return, but since the contribution was made November 1, it's only deductible in the 2021 tax year, not the 2020. However, because it's made within 30 days of the due date of the 2020 tax return, it's considered an annual addition for 2020. Just, further complications. Okay, so the gist of this slide is given the ability to retroactively add a QNET type contribution with the retroactive adoption. Keep in mind, you can't retroactively add QMAX. This is only available to retroactively add a safe harbor arrangement to your K plan through the use of QNET contributions. You can do that and not have to worry about the maybe notice unless you want to use those QNECs to also satisfy the ACP safe harbor, in which case you will continue to need to give out the maybe notice before the beginning of the year. And the bottom line on most of this, to cut to the chase, is there are very few plans that really get out of having to give the safe harbor notice on a going forward basis. We are looking at it. I think we've talked to Nova, and we're probably going to continue to do what we've always done and recommend to our clients to continue to give out the notice, even for a safe harbor plan with a QNEC and an ADP safe harbor only. It's more trouble than it's worth. And so the last point to be made, again, the Secure Act remedial amendment period goes to 2022 and 2024 for governmental plans. I think there's also that for collective bargaining plans. I'm sorry, I'd have to refresh my memory real quick. But in any case, the notice clarifies that if you want to add a retroactive QNET to your 401k plan for 2020, the deadline would normally be 12/31 of 2020. You actually can have until the normal, the Secure Act amendment deadline. And otherwise, folks, I have, it's right at 59 minutes after the hour. We have filled up all of the hours. We might have time for one question if there's a good one.
Hi, Craig. Yes, we did receive one question. So that question is, how does the partial termination release interact with PBGC reportable event requirements? Oh,
that's a very good question. I'll be honest with you. I do not know off the top of my head. I'm not aware of PBGC. Otherwise, I need to look at it. That's a good question. I'm sorry, I don't have that answer. The questioner, if you'd like to reach out to me, you can reach me through my Nova email, choffman@nova401k.com. I apologize. That's a good question. I'm interested in the answer myself. Sorry, can't know it all. That's it, Andrew. I think we've used our allotted time.
Okay, thanks, Craig, and thanks everyone for joining us today for the webinar on the 2021 update. Please note there will be a survey that will pop up right after the webinar ends for you to complete if you need CFP, IRPA, or ASPA CE. So just be on the lookout for that. These certificates will be sent out in 1 week, and a recording of this webinar will be made available on our NOVA YouTube channel by the end of next week. If you have any questions, please email us at webinars@nova401k.com, and everyone have a terrific Thursday.
Stay warm and safe.